Good afternoon, everybody, and welcome to our interactive webinar, which we are collaborating with our members, Cerebra CPAs partners and Moroğlu Arseven law firm. We have got experts on today's event. I would like to welcome our two speakers. We have got Fikret Sevilcioğlu, who is the managing partner of Cerebra, and Burcu Tuzcu Ersin, who is the partner of Moroğlu Arseven law firm. We welcome everybody to get into the Q&A session at the end. Now, I would like to hand the floor to our moderator, Fikret Bey. Thank you.
Thank you, Dilruba Hanım. Thank you all, and welcome to our webinar this afternoon. Thank you very much for introduction, Dilruba Hanım. Let me introduce myself and my firm, and then I'm gonna hand over to Burcu for the introduction. My name is Fikret Sevilcioğlu. I'm the managing partner of Cerebra, accounting and advisory firm. It's an Istanbul-based company. We've got two lines of business, accounting department and consulting. In the accounting, we provide services to our foreign clients invested in Turkey. And in the consulting department, we provide services in the areas of process improvement, internal audit, internal controls, fraud examination, white-collar crimes, forensic accounting, and also in the last couple of years, we focus on ethics-and-compliance-related services, such as whistleblowing, anti-bribery services, corporate intelligence, and third-party risk management. And to be quite honest, I'm quite excited to be a part of this event. As Cerebra, we've been a member of BCCT for a long time, but this is the first opportunity for me to speak at the BCCT event. So thank you very much for this opportunity. So as an introduction, Burcu, it's over to you.
Yes, well, thank you, Fikret. Hello, everyone, and thanks for joining us today for this presentation that is hosted by BCCT. I'd like to thank BCCT and also my co-panelist Fikret for the opportunity and to collaborate this all together. I would like to start by our firm, Moroğlu Arseven. Moroğlu Arseven is a full-service law firm based in Istanbul, which is established in 2000. We have 87 people in place, and more than 60 fee earners that are working on different areas of law. We have four main pillars that we are working on. Corporate commercial is one of the leading spaces where we work. This is also, tackled by litigation, which is then coupled by IP and compliance services. Internal investigations is an area which we're heavily working on and highly specialized in. I have been with the firm for more than 10 years right now, and I have been a partner of the firm. My focus area is, and I'm a lawyer myself since 2001, I would say. I have been practicing heavily on corporate commercial matters and compliance matters, including investigations. Maybe I can stop here and...
Okay, thank you for the introduction. So let me share our presentation then, and then delve into the details of the fraud investigations. Today, just a second, another on the screen. Yeah. Today we are going to talk about fraud investigations, internal investigations, so what do you call? So it is, in my opinion, one of the most difficult and challenging tasks of business organizations. And also by their very nature, tend to involve accusations of wrongdoings against employees within the organization. So it's quite sensitive. And also it can lead to a variety of legal problems and other unexpected consequences or complications. And another feature of investigations, it requires numerous judgment calls during the conduct of investigations. And most of the time, the answer of these questions may not be like black or white or cut and dry, because most of the time we can find ourselves in some ethical dilemmas. Therefore, it's quite difficult, challenging task for managers, and also the managers or the board of directors. They do not come across a lot investigations during their professional lives. Therefore, the company's policies and procedures are not well designed to respond to this kind of tasks. Therefore, in the next couple of next one and a half hour, we are going to talk about all significant elements of the internal investigations. So let me go through the agenda just for your information. First, we are going to focus on the unethical or illegal issues in organizations for you to understand the universe of the misconduct. And then we are going to get into fraud and initial detection of fraud, whistleblowing, and then why conduct an internal investigation, deciding whether to initiate an internal investigation, planning of an investigation, collecting evidence, interview, and the last one, report writing. And after report writing, we are going to focus on corrective actions, legal remedies, and reporting requirements. Okay, let's focus on first, what's the universe of misconducts in the business organizations? The first, fraud. Just at the beginning, I want to remind one thing. We are going to focus on the fraud investigation during our event, because fraud, compared to other misconducts in the business organizations, has a typology and has a much better designed methodology, let's put it this way. That's why we focus on the fraud, but shortly I'm going to share the other misconducts. The methodology we are going to propose in this event can be easily applied to other misconducts in your company, or to the other investigations of the misconducts in your organizations. And misuse of company time and resources, abusive or intimidating behavior, lying, conflict of interest, corporate intelligence, discrimination, sexual harassment, insider trading, intellectual property rights, privacy issues, market abuse. Yeah, these are all, I think the major parts of the misconducts are all included in this slide. Maybe we can miss some, but based on our experience, we touch here most of them. So before proceeding, I just want to focus on a little bit fraud for you to shape better in your mind what's the border of the fraud. And fraud has three main categories: corruption, asset misappropriation, and financial statement fraud. I mean, it's going to take too much time to get into each of these fraud schemes. But corruption, just briefly, includes conflict of interest, bribery, illegal gratitudes, and economic extortion. And asset misappropriation is much more related to embezzlement of the assets of the company by the employees, like cash, stocks, or intellectual capital, for example. And the last one, financial statement fraud, is related to all overstatement of turnover, understatement of costs, liabilities, timing differences, or lack of disclosure, something like that. So these are the fraud three. And we call it actually occupational fraud in accordance with Certified Association of Fraud Examiners. So let's go forward. What's the global cost of fraud? In accordance with the report of ACFE, Association of Certified Fraud Examiners, the Certified Fraud Examiners estimate that organizations lose 5% of revenue to fraud each year. This is astonishing ratio, in my opinion. And also in the report, just to reflect better the impact of fraud globally, considering that 90.5 trillion gross domestic product all over the world. So it's calculated that 4.5 trillion lost to fraud globally each year. So I think it shows that the fraud is quite a big issue for organizations, especially in such a competitive environment. Fighting with fraud can really help you. Maybe you can find it a little bit interesting, but make money. Because considering that 5% is quite high, if you can make it 4%, for example, or 3%, you can have a great plus at the bottom line. So how is the occupation fraud committed? Coming back to three categories of fraud schemes. Asset misappropriation involving an employee is stealing or misusing the employing organization resources occurs in the vast majority of fraud schemes, like something like 86% of the cases. However, these schemes tend to cause the lowest median loss, like 100K. In contrast, the financial statement fraud schemes, and in which the perpetrator intentionally causes a material misstatement or omission in the organization's financial statements, are the least common one, almost 10%. But this is the costliest category of occupational fraud. And the third category, corruption, which includes schemes like bribery, conflict of interest, and extortion, falls in the middle in terms of both frequency and the financial damage. These schemes occurs in some 43% of cases, the median loss of some 200K. So this is shortly fraud in accordance with the data reported in the Association of Certified Fraud Examiners study. So now I'm just going to hand over to Burcu. Burcu will give you some information about fraud under Turkish law.
Well, I mean, now we're talking about a broader definition of fraud than we are regularly understanding under Turkish law. I have to mention that fraud can appear in its rather broader definition in different forms. And therefore, it is governed by various legal sources. So there could be a number of criminal offenses that may come into play under the Turkish Criminal Code in respect of the fraud treaty that has been shown by you, Fikret. One of the items, one of the criminal offenses that we may speak of is the fraud itself, obviously. This is one of the serious offenses that is considered under Turkish Criminal Code. And it's actually defined as creating a benefit personally or for other people by means of deceiving persons with fraudulent acts at the detriment of these or other persons. Basically, there are certain elements to that crime. Deceit is one of them. Deceit with fraudulent acts is one of them, which is actually one of the key elements of fraud. And detriment of other people in the benefit of the perpetrator or somebody else than the perpetrator is another element. Of course, fraud is committed by intent. We are going to come to that later on, so I don't want to get into detail on that. But there are other crimes that are also coming into play. Bribery, which includes foreign bribery. And although Turkish Criminal Code and Turkish law doesn't specifically regulate private bribery, we still have certain provisions that we have to be carefully analyzing while seeing certain fraud schemes in corporate environments. Because, for instance, publicly held companies can be considered to be involved in bribery issues. Or foundations or associations, these could be also considered to be placing bribery in certain conditions. So we have a breach of trust and embezzlement, which are two different versions of the similar crime, I would say. One on the private side, one on the public side. We have accounting fraud, which is not existing under criminal code, but the tax procedure code. And this is really an important provision in respect of the misappropriation of the financial statements. We have bid rigging and forgery of money, forgery of documents, you know, and official documents, different types of forgery, I have to say. I didn't get into market abuse because competition law is completely a separate area, which we try to tackle in this presentation would take most of the time than the current subject. So I leave it aside, but I also include capital markets fraud and market manipulation as it is defined under Article 107 of Capital Markets Law, as well as insider trading, which is also a very typical crime that can take place in corporate environment. So these are the criminal offenses which are relevant to our topic today. There could be more depending on the scheme and circumstances, but these are the more fundamental ones that we're talking about. Obviously, fraud can also constitute tort, depending on whether the conditions are met or not. Most of the time, the conditions are met, but I mean, we have to analyze this case by case. And also, fraud can have impact on contractual, arrangements. I'm sure that the legal colleagues participating in this presentation already is aware of its consequences, but it could have certain serious impact on the establishment, the constitution of the contract, as well as the execution of the contract. So I think this is a good start on the legal side, at least a general overview under Turkish law that I can present.
Yeah.
I can leave the word to you for the next slide, I guess.
It is actually, Burcu, thank you very much. I think the audience has much better insight about fraud globally and the categories of fraud and also fraud under Turkish law. So let me give you a little bit more information about how fraud is detected. Actually, this slide will pave us for the internal investigation. How fraud is initially detected. In accordance with the report of the Association of Certified Fraud Examiners 2020, the 43% of the fraud cases are detected by tips, 43%. And the second effective way to detect fraud is internal audit by 15%. And the third one is 12% management review. Can you imagine that internal audit 15 and management review 12 and tips on a standalone 43%? And if you look at the rest, by accident 5%, account reconciliation 4%, external audit 4%. For example, for a business organization, if we sum up internal audit and external audit, in total 19%, the initial detection, the impact on the identifying of fraud cases, and tips on its own 43%. It shows that tips extremely effective way to detect fraud, and it shows the importance of the whistleblowing mechanisms and also speak up culture in the companies. Why I'm raising this matter? Because most of the time we are going to talk about shortly, and Burcu will especially talk about whistleblowing mechanisms in the coming slides. Because tips is quite effective, and by making relatively less investment and creating, fostering and nurturing a speak up culture, you can detect fraud. And in most of the time, internal investigations are triggered by this kind of tips. So in the coming slides, we are going to talk about internal investigations, but just consider that all of them are triggered by tips given by employees sometimes, but not only employees, sometimes by third parties. So we will just get into a little bit whistleblowing. So it's over to you, Burcu again.
I would like to speak about in a few slides on the general environment on whistleblower protection. I think you very well pointed out why it's necessary and why it's important. I'd like to speak about the situation just roughly in the UK and how the legislation is developing in the EU, and then turn back into Turkey. You may, you may question why all these three different areas are covered, but I mean, obviously, in a cross-border internal investigation scene, these have all significant interplay with each other. And as a lawyer, you may be required to make analysis coming from different jurisdictions for the same topic in question. Whistleblowing in the UK has a history. It has a history from 1998. UK has been considered as one of the key jurisdictions which has comprehensive whistleblower protection laws. I would say they have one of the most well-developed, but still maybe still need certain reforms sort of laws that are coming after the US, I would say. So the prime legislation is the Public Interest Disclosure Act, which makes changes to the Employer Act. So there are two major protections that are granted to the employees here. First, I mean, the employee, if the employee makes a protected or qualified disclosure of certain categories of failure, and these are all classified under the law itself, then the employee will benefit from non-retaliation, I would say, that there should be no detriment to the employee by the employer. And also, the employer cannot make any termination of the employee afterwards, and it may be considered as unfair termination. Compared to its counterparts in the US, there are a few areas where the UK 98 legislation could be improved, maybe. These could be the public disclosure provisions, because normally the disclosures here are done first to the employer, are rather weak and rather more procedural, I have to say. And there is no requirement on the institutions to establish whistleblowing mechanisms or channels under this law. And there are no rewards granted to whistleblowers, which is not the case in the US counterparts, for instance. It's arguable whether or not the reward mechanism is the best approach to that, but obviously it is also still considered an upside in the US. So in practice, actually, how PIDA applies has been criticized heavily, because there have been a lot of termination cases which are pending before the UK courts. And it takes a lot of time for those cases to come to an end, and most of the time it's unfavorable to the employee. So if we go to the European scene, Europe has recently adopted the directive on whistleblower protection. And it actually entered into force on 23rd December 2019. It provides 2 years' time to the member states to adopt the provisions of the directive into their national law. And this is ending on 17 December 2021. The directive has been a long-awaited piece of legislation, I have to say. It has been heavily worked before it's established, and it brings forward the minimum common standards among the member states towards whistleblower protection. So obviously the member states are encouraged to provide more in-depth regulations which are minimally qualified with the directive. So a lot of good protections exist, but I think the main pitfalls could be it only relates to EU law because of the mandate of EU, obviously. And it provides protection to a very, very enlarged audience. But still, journalists have concerns around whether, journaling activities, especially forensic journaling activities, investigative journaling activities would be really benefiting from those. It applies to workplaces with more than 50 employees. And in that case, there has to be a whistleblowing channel and investigation system establishment requirement that is existing. And I mean, of course, it provides non-retaliation and unfair termination for the employees. So still, this doesn't have any reward mechanism included. So I would say it's not in practice yet. So we need to see how the directive will be perceived when the practice of the law will start after this year. So if we go back to Turkey, the situation in Turkey is, I have to say, there's no specific whistleblowing legislation existing in Turkey. There are a number of provisions in different legislations. These are dispersed into different sources of legislation under Turkish law, and you may use those provisions during your analysis in respect of the situation in hand, I would say. We have one specific clause in our employment law which provides the employee the benefit of not being able to terminate in the case of submission of a complaint by the employee against the employer to administrative or legal authorities. But I have to say, that's a very limited protection that is coming from the ILO conventions that's adapted to our law at a later stage. But although that provides a certain level of protection, it's a very, very narrow one. So we definitely need an overall whistleblower protection structure, and that has been heavily criticized both by OECD and also by UN and also by EU in our accession talks with the EU. Chapter 23 has specific code on the whistleblower protection regulations that needs to be aligned by the new EU acquis on the issue. So let me just again leave the word to Fikret, and we can.
Thank you, Burcu. I think we have a much better.
By the way, I think we can now open our cameras. I think that was because the slide was affected.
Unfortunately, I'm unable to start the camera. I don't know.
The same applies to me. Maybe we can inform BCCT on that. Somehow the video stopped.
Let us check, please.
Okay. Thank you, Burcu. So we have much better understanding of importance of tips, and Burcu also provided a very good insight about whistleblowing mechanisms and how they are applied in the different jurisdictions. Start just a second. Yeah, now it's working. Now we are going to delve into the details of the internal investigations. Why we conduct an internal investigation? Definitely, I mean, based on our explanations, I'm sure you have much better understanding that internal investigations are an important part of the company's corporate governance system as well. The organization's commitment to ethical values and the corporate to the integrity of corporate culture is quite related with the internal investigation, because internal investigation is most of the time is the final touch of the ethics and compliance programs. The company is putting lots of effort on the EC, ethics and compliance programs, and but whenever any suspected issues or allegations occurs, the responding to these allegations and suspected actions shows your commitment to the ethical values and your EC programs. So, okay, let's start with let's start with why we conduct internal investigations. There are some benefits and pitfalls, definitely. Let's take a look at the benefits. Whenever we are considering an internal investigations, the major aim of the investigation is to identify improper conduct. What's the fraud scheme, or what's the type of the misconduct? We would like to know that. And also to identify employees, employee or employees, group of people, or maybe the third parties responsible for this improper conduct. It stops immediately the misconduct. And as a result of the internal investigations, we determine most of the time, maybe not full, but the amount of the loss or damage to the company, which is quite important, especially if we are going to take a legal action. Shows the internal investigation activities, I think is a quite good reflection to show the tone from the top and the lead by example, because the responding to misconduct by the top management shows the commitment of the management to the ethics and compliance program or ethical culture of the company. And it's a great opportunity. I'm seeing opportunity, although we are talking about fraud or maybe misconduct, is to nurture and foster the speak up culture in the company. If we respond properly to internal investigations, it definitely develops a speak up culture. It helps facilitate the recovery of losses because we know the details of the misconduct of fraud schemes, and definitely it's going to facilitate the recovery of losses if we take proper legal actions. Burcu will talk about this later. It's going to stop future losses and identify remedial steps, and last but not least, strengthen internal controls, which is going to definitely prevent the future losses again in the company. So these are the benefits. What are the pitfalls? This is costly activities. Most of the time we are going to engage internal sources and external sources, and we are going to incur cost for internal investigation. Sometimes it's going to cause disruption to the business. This is also resulting in costs, of course, to the company. Sometimes it's hidden impact, maybe the adverse impact on employee morale, especially based on my experience. As said before, these fraud investigations are not very common, and normally people are not used to react this kind of investigations, and they are impacted immediately and badly, and their morale is deteriorated. So it should be considered as well. And internal controls, if they are not conducted with the utmost care, it can lead to a wide variety of legal problems and other unexpected complications. So these are benefits and pitfalls that we should take into account before getting into internal investigations. So now we are going to talk about to decide whether to initiate an internal investigation. It's over to you.
Yeah, thanks, Fikret. So I think just like the requirement to adopt and enforce compliance programs, there's no right or wrong that applies to all jurisdictions or company types when the question comes to whether to investigate or not. I think it's important to have, decision-making tree sort of questions lists and criteria lists that has to be really answered and tackled throughout the process of this decision-making. I think the first question would be, are there any legal requirements to investigate? This is a very critical question that has to be coming in the upfront, I have to say. There could be legal requirements, under the law or regulations to have and conduct an internal investigation, or there could be certain benefits derived from laws or regulations to have your own internal investigation when you come up with an incident. Apart from the laws and regulations, the company's internal rules and procedures or compliance, if there's any compliance program that has been adapted and applied, that kind of compliance program could require the company to make the investigation once there's any awareness of an incident in the company. Under Turkish law, there's no specific requirement to conduct an internal investigation that is imposed on the corporations in a regular corporate offset. So our laws doesn't have any obligation over the company organs to fulfill those kind of activities. Obviously, there are certain general duties of care or other duties of the board members that are imposed under Turkish Commercial Code, but I'm going to speak about those right now. So even in the absence of any specific legal requirements, I think it's important to understand the liability framework over here. I mean, you are faced with an incident, and whether to investigate or not could be an issue about the liability surrounding that incident. Who is liable from the event? Is there any individual liability, or is there any corporate criminal liability? I mean, are we talking about criminal liability at the first instance at all, or are we not? And then if you're talking about criminal liability, like I said, is it individual or corporate criminal liability? Turkish law doesn't accept the concept of corporate criminal liability. I think that's one of the thumb rules that we can state here up front. Therefore, the legal entity, if there's any crime that is facilitated by the legal entity or that is happening inside the legal entity itself will not be made subject to criminal liability. The persons, the individuals who are involved as the perpetrators of that crime will be liable from the criminal offenses. Of course, the legal entity, that doesn't mean that the legal entity will not be liable at all. There could be certain security measures that could be applied to the legal entity on the way, which may be very critical and may create certain business disruptions, as the way you suggested, Fikret, in your previous slide. So there could be some license cancellations, there could be seizure of assets that are used or benefited from the crime. There could be custodian appointments. There could be different number of security measures that could apply to corporations. I think it's also worthwhile to mention that in cases of bid rigging or fraud or bribery, money laundering, set of crimes, there is also certain monetary fines that are imposed on the legal person under the Misdemeanors Act. Although these are not so high figures in comparison to the Western style laws, this is still, I think, an important aspect to keep in mind. So in circumstances where any crime is commissioned in a corporate environment, the board members, directors of the company may be laid with charges, or even be held liable in cases where the crime is committed in the context of company's business. here I have to get into some technical details, I guess. Fraud can only be committed by intent, like, you know, bribery, some other crimes, offenses that I have mentioned here from at the start. They can only be committed by intent, but not negligence. But obviously that also means that those crimes can be committed by legal intention, which is a concept in Latin called dolus eventualis. In Turkish, we call it olası kast. Intent in the form of dolus eventualis is deemed present when the perpetrator objectively foresees the possibility of his actions, consequences, and persists on doing the, acting upon, regardless of the consequence. So basically, this means that I will just give you a very simple example. If the perpetrator is aware that driving with alcohol could lead to certain harm to other people, but still persists on doing that, that may be considered as a legal intention here. So it's really critical to understand the director's duty of care and the business judgment rule around that. Although our commercial code doesn't specifically and explicitly provide any reference to the business judgment rule, the interpretation around the level of care that directors has to comprehend in the joint stock companies are done through the business judgment rule. Anything that's remaining within the business judgment rule may not be considered as an intent, but anything going beyond that, if you're reaching beyond the limits of the business judgment rule, then there could be the intent or dolus eventualis happening in the case, which may be critical for the liability of the directors who are not directly perpetrating the crime. So I think another question to discuss is, are there any legal requirements or advantages to report to judicial or regulatory administrative authorities? I have to say here, our law is pretty unique. Failure to report a crime that is still being commissioned or consequences of which continues is considered itself as a criminal offense under criminal code. And the crime is sanctioned up to 1 year imprisonment. I can imagine that most of us already know that the application of this provision is very rare. But still, it's a concern in the corporate environment when making the decision to investigate or not. Self-reporting can be considered a possibility in certain circumstances. Obviously, legal analysis, thorough legal analysis is required to make any self-reporting because there could be certain disadvantages to that. Maybe also certain advantages, although they are not defined under law. I mean, I have to say, especially in the circumstances of highly potentially facing external investigation, this could be a possibility to consider, in my view. And there are certain disclosure requirements that are imposed to publicly held companies. These are not reporting requirements, so this is not actually a typical reporting to a governmental body, but rather a public disclosure that has to be made in case of the occurrence of material events. It's very detailedly regulated under Turkish law, but especially in an environment where we're talking about a publicly held company, the board members and management is also under pressure to test all the time whether the disclosure requirements are met or not. That's also an important aspect to consider whether you want to investigate the incident in your company or not. So I think I would like to discuss a few about the immediate concerns that can come on the agenda. You know, once you decide to initiate an internal investigation, I think the key element that comes up front is the confidentiality. Because, I mean, who knows this? Who knows the incident? And who knows if it's reported? Who knows it's being reported? Or if it's discovered by another way, who knows that it's been discovered by the company? And who knows the details of the issue? This is really important. A shield on confidentiality is definitely needed by the company. And it's also utmost importance to preserve the evidence and records if those are to be used in the investigation at a later stage. You may not know whether you will be using any evidence or any information that the company is holding at the time of discussing around whether to initiate the investigation or not. But I think it's very critical at that moment how the company can preserve the data that could be relevant to the investigation. The need for attorney-client privilege, that's something that is also critical, especially in the case of criminal offenses, I have to say. In that circumstance, the company has to have a careful thought on whether to benefit from any attorney-client privilege. Our law doesn't have specific detailed regulations on attorney-client privilege. Though we have a blanket provision in attorneyship law, which provides the obligation on the attorneys to actually protect and not disclose the data that has been held while conducting their profession. There is also certain other protections for the lawyers in case of search in the law offices. Like, attorney-client privilege material could have a different special treatment. And I think it's important to also discuss in detail, if any attorney could be structured in the communications as a strategy to understand whether attorney-client privilege could be benefited or not. So I think I'm going to stop here on the slides.
Yeah.
And you can...
Yeah, these are all quite valuable points. And let me just contribute a couple of things from my perspective as forensic accountant and fraud investigator. So as Burcu said, if the company is required to perform internal investigations, so they must. But most of the time, there might not be such a requirement. So this slide actually shows us that you should stop or proceed as far as the internal investigation is concerned. If we perform our initial assessment and if we find the evidence or suspects or allegations credible, then we are going to proceed and we are going to start collecting evidence, interview, and then report writing. So we are going to proceed. And if we do not find credible these evidences, then we are going to stop here. So it's extremely important moment, in my opinion, during conducting internal investigation. So if we decide to proceed, then we are going to get into the internal investigation. I don't want to stay too much here, but I just want to draw your attention to the importance of planning. Of course, this is based on the complexity of the internal investigation and the importance of the allegations and the findings that we initially assessed. So first of all, we have to start the investigation. That's quite critical. Most of the time, of course, legal counsel, internal or external legal counsel, are engaged. And based on the type of the fraud scheme or misconduct, also we should decide what kind of team members should be engaged in the internal investigations, such as fraud investigator, forensic accountant, security experts, digital forensic experts, something like that. So that's quite critical. And then we should learn about the organization under investigation. Then we should review what is known to date up to that point and gain a basic understanding of the key issues that is impacting the misconduct. And then we should define the goals of the investigation and identify whom to keep informed. That's quite critical. Burcu referred somewhere during her presentation. So most of the time, we should inform based on the need-to-know basis. That's quite critical for the confidentiality of the internal investigation. Determine the scope of investigation. Most of the time we spend too much time because fraud investigation should be scoped quite well in order to focus on the allegations and the misconduct. And then establish the investigation's time frame. Sometimes it's not possible to determine the time frame because the new information might come to our attention during the internal investigation, but in a draft way, we should have a time frame. And define the members' roles and assign tasks. I mean, at the first stage, we staff the investigation, and then here we should define the members' role and assign tasks. And during our preparation, Burcu just shared her experience. Burcu, you want to share your experience regarding this matter?
Yes, I mean, I think it's quite important to just one add up maybe before sharing the example. Sure. I think it's quite critical to ensure that the investigation has a specific focus and scope, as Fikret mentioned. You know, during the investigation, since there will be potentially a number of team members involved, the investigation leads to different areas and to different agendas, actually. So I think it's quite critical to not to deviate from the focus of the investigation the whole time during the internal investigation, unless there is a specific consensus in the investigation team and a clear mandate that further wrongdoing needs to be assessed. So there could be other things discovered during the investigation. And as long as they are not linked or related, the investigation team should be focusing on the main topic always. Team building, it's important to identify the team members who will be involved in the investigation. I also saw a question in the chat box, so I would like to take that as well. I mean, depending on the size and topic of the investigation, different characters can lead the investigation team. That really depends on the circumstances of investigation, the needs of the company, and what's happening in relation to the investigated matter. But in terms of team building, it's really critical to have as minimum people as possible inside the team. We have seen examples, I mean, in my experience, I have seen examples where there have been members of the team involved in the investigation just because the company policies would require like that. But then those people were put in a position to investigate their reporting lines. So, I mean, this is an issue that's obviously not ideal because both for the investigation team member, for the sake of the investigation and the investigated person, this is quite an issue that has to be considered from the upfront. A very, very thoughtful process needs to be held here.
Yeah. Thank you. And let me continue the other elements of the planning. So we should also address operational issues such as limitations. So these limitations could be a language if we are talking about a multinational company, for example, operating in many countries, cultural differences, and the most recent one, I think it's we are all having difficulties because of COVID-19 impacts. So as for the investigators, we are having quite a significant difficulties to conduct fraud investigations remotely. So it's quite a big limitation. So it should be considered, of course, and travel restrictions. Coming to an end in the planning, we should have an investigation plan. If we are talking about a complex and a large internal investigation, it's always good to have a investigation plan to institutionalize the activities. Otherwise, it could be quite difficult to discipline the activities within the internal investigation, and adapt the necessary resources. When I'm saying resources, time and money, of course, especially regarding the staffing the investigation. If we are going to engage external, especially external advisors, individuals, then it's going to take some time to share the scope, agree on the scope, and engage them. Preparation of the engagement letter, this kind of stuff. These are all going to take some time, and of course, at the end, money. So all these time and funds should be properly resourced. Okay, let's get into the collecting evidence. Another significant...
Maybe I can give
Sure.
a few other items that I consider important.
Sure.
I mean, although you mentioned very well, I think it's really important to put the time frame and to put a concrete step plan on how you're going to investigate. Timeline could be very critical because I mean, especially by the in case of cross-border investigations, the effect of the incident into the company's financials could be a major topic that has to be addressed properly and timely. And for that reason, I mean, the company may be in a urge to investigate the incident as quick as possible or up to a certain deadline to make sure that that impact into the financial is presented. So that's one aspect that we see a lot while conducting investigations. Another thing could be there could be a statute of legal statute of time limitations, which would really avoid the company to be able to make certain assertions after a certain time period. That is also quite critical while assessing the timeline of the investigation. And in terms of the step plan and investigation plan, it's always useful to come back to that plan in time, because during the investigations, the things may be going in a direction that is not planned before. So it has to be resonating in the investigation plan all the time. We should be considering it as a living creature, just like us. And we have to be adapting the internal investigation plan, just like the way we adapt our legal analysis or legal solutions to the flow of cases in our hands.
Thank you. Okay, so as said before, another important element of the internal investigation is collecting evidence. So before sharing my main slide, I just wanted to put this data. This is quite striking, in my opinion. So this shows how occupation fraud is concealed. Because at the end of the day, fraud is concealed. It's hidden. That's the main difficulty. And fraudster is always lots of steps ahead of us. And also most of the time they spend too much time to identify how to conceal their crime. So this data shows that And also, just an information, this report includes 2,504 fraud cases all over the world. So 40% of these fraud cases, in 40% of these fraud cases, physical documents were created fraudulently. 40%. This is incredible amount. And in 36% of the fraud cases, physical documents were altered. And in 27% of the cases, electronic documents, digital documents were altered. And 26% electronic documents or files were created fraudulently. So I think this is extremely important data for internal investigators, for the investigators, for internal auditors, to understand the importance of the forged physical data, counterfeited physical data, or electronic data. And interesting to know that at the bottom of the slide, you can see 12% did not involve any attempt to conceal the fraud. This is a little bit ridiculous, but it also, I think you should know that. Okay, let's get into collecting evidence after getting this data. Please keep in your mind. So we've got three types of evidence in internal investigations. Documentary evidence, we call it physical document, digital evidence, digital document, and the testimonial evidence, we call it. It involves statements made by witnesses. Examining fraudulent documents are quite challenging and difficult practice, and nobody expects internal investigators to be a forensic document expert, because there is a profession called forensic document examiners. Because in our investigations, most of the time we face with forged documents, fabricated documents, altered documents, and other suspicious documents. And these are quite valuable for us to evidence that fraud occurred, and also to identify the people who commit this misconduct or fraud schemes. Therefore, it's extremely important. And just for your understanding, I want to share a couple of types of forensic document examination. You are going to shock actually when you see the list. I'm just going to read. I didn't put here because there are lots of different types of fraud document examination. For example, detecting forged signatures, identifying the writers of signatures, handwriting and handprinting, detecting altered documents, detecting and restoring erasures and eradications, determining when a document was or was not prepared. Can you imagine that the forensic document examiner can identify when or when not this document is created? That's quite interesting. Detecting counterfeited documents and examining printed documents. Let me just go through comparing, for example, torn or cut paper edges, restoring charred or partially burned documents, identifying the machine that made a photocopy and when two copies were made on the same machine. And the list just goes like that. And it shows that there are many types of forensic document examinations. And if you're aware of this, definitely, based on the, of course, the fraud scheme, you are able to use these professionals as part of your internal investigations. Okay, let's talk about a little bit handling documents as physical evidence. As said, we've got two evidence. If we put apart the testimonial evidence, physical evidence and the digital. Let's a little bit focus on the physical evidence. That's quite important for us, still important to us. When I'm saying still, because the companies are predominantly using digital documents in the last maybe 10, 20 years, but still there are lots of physical documents that we come across in the companies. During internal investigation, we must be we must handle physical documents with utmost care. What I'm trying to say, especially physically, we shouldn't change the form of the physical document, because if we can identify the right document, and if it's going to evidence the fraud incident, then it's extremely valuable, admissible evidence in front of the court. That's why we shouldn't change the form of the physical evidence for the sake of the chain of evidence. Burcu will talk about it later on. So the original document is extremely important. When we are performing internal investigation, we should get a copy of the original documents, and we keep aside the original one. And most of the time, we are going to share the original one with the forensic document expert, because it is pretty important to compare original documents with the fake or forged or counterfeited documents. Recognizing counterfeit documents, although I have stated that in examining fraudulent documents, we may need forensic document expert, but most of the time, and still work out a lot in many fraud investigations I was involved, we are able to identify many suspicious points regarding the physical documents by just observing the original and the suspicious documents, by comparing side by side. It works out, believe it or not. The issue is that most of the time we are not aware of that the documents that we are handling could be fraudulent or not. So if we are quite careful on observing some elements of the documents we are encountering, then we are able to identify many suspicious points on the documents. For example, for forged signatures, in many investigations with my team, we were able to identify obviously forged signatures just by comparing the original signatures with the suspicious signature. And also most of the time you can see the lines on the documents where the photocopy of the signatures were used on the document. So all I want to say here, the point I'm trying to make it here, just trust yourself, observe the documents in detail, and be careful and compare side by side the suspicious document with the original one, if it's possible. Then I'm sure you will find good points for your investigation. And let's talk about now digital evidence. This is another area, and also it's getting more and more important because the companies utilize digital evidence in the last 10-20 years with the development of the technology. That's why it's extremely important for internal investigations. Why it is important? Because you can just save in many devices easily, and also this can be quite a big amount. For example, hard drives, printers, mobile phones, tablets, digital cameras, smart watches. These are all devices that process digital data that we can use in our internal investigations. Why it is important? Because volatility of the digital evidence. Digital evidence is more volatile than tangible information because it can be altered quite easily. Even harmless actions, I'm just underlying, harmless actions on digital data may destroy the very valuable digital evidence for our internal investigations. What I'm trying to say, the harmless actions, for example, shutting down a running system. or starting up a system, or looking through files on a running computer. So this is all about awareness of the digital data. If we are aware, all we need to do, if we face with any devices that might include valuable digital evidence, then we must definitely talk to digital forensic professionals to help us how to handle these devices and the digital data. Otherwise, as said, we can destroy the evidence, and the admissibility of the evidence could be in danger. Types of data that can be recovered from computers, most of the time, if the fraudster can feel that something is going on, and if we do not take proper action at the very beginning of the internal investigation, sometimes fraudsters may delete valuable digital data. But if we are aware of this, and we can engage digital forensic experts to help us to recover these digital data from computers or from devices, whatever it is. And the last point is e-discovery. Because of the amount of digital data, it's not possible in many investigations to review this huge amount of data. Therefore, in the last years, e-discovery softwares are just helping us to analyze, to identify the suspicious digital data. So I recommend that if you are in a situation where lots of digital data and you must review them, so e-discovery program might be used. So it's over to you, Burcu, for legal remarks. By the way, we've got 15 minutes.
Okay, I think we can wrap up in 15 days. I'm hopeful.
Yeah.
Yeah. So yeah, I think when talking about collecting evidence, it's important to touch upon a few aspects, especially when we come to any criminal proceedings. It's really important that any evidence that we submit to the court should be gathered legally. So without gathering the evidence on a local process, the court may dismiss the evidence. That's really critical, and in most of the internal investigations, a huge effort is put on identifying the evidences and qualifying them from a legal perspective, whether this could be used in legal or criminal or civil proceedings or not. You know, apart from the criminal proceeding assessment that has to be made, there are a number of important legal sources that comes into our minds. Before the enactment of the data protection law, the mere provision in respect of processing of personal data of employees was sitting in Code of Obligations. And I'm not talking about the, Turkish Criminal Code regulations, etc., and other, constitutional, more general frame sources. I'm only speaking about, employee data here. And the respective provision was suggesting that the employer could only process employees' data so long as it is compulsory for purposes of performance of employment contract or for competency of the employee. And most of the time, we were trying to tackle this provision by assessing whether the internal investigation or whether any analysis is falling into the assessment of competency of the employee or not. After the enactment of data protection law, of course, the lawful, the legal processing principles has been laid down, and many further procedures has come into play on how to process the personal data of the employee. I think the whole process, although constitutional court decisions are not considered as direct legal sources, they still need to be followed by the judiciary, therefore by the practitioners like us and the companies, obviously. So a recent constitutional court case clearly set out the rules on how to conduct surveillance of employee emails in the environment of employer's workplace. This is not the first constitutional court decision that has been taken on the same topic. There has been previous instances where the court applied certain principles in this regard. Though it's very critical because this is the first time that the court makes a decision on that after the enactment of the data protection law. And the principles that has been established by the court is quite identical and following the European Court of Human Rights decision, which is named Barbulescu versus Romania. This has been a very famous decision that is sort of a framework decision that is applied all over the Europe for also internal investigation circumstances. And we really give utmost care on all of the principles and elements that we are referring to here. I'm not going to get into all the details of those principles, but it's very critical to come up just with a few items as a reminder. First, it's important to assess whether there's any legitimate interest. It's important to assess upfront, information on the activity level of the employer. And this means, this doesn't necessarily mean that today I'm informing and tomorrow I'm going to make a monitoring of the last 5 years. This could not be happening like that. So there has to be a proper information to the employee around the activities of the employer. And apart from the principles, I'm going to touch upon the cross-border processing of the data, because in most of the times, cross-border internal investigations require the traveling of the data. And this is where we have a lot of issues around whether to check emails, whether to check, device mirrors, whether to conduct forensic investigations or forensic reviews outside or inside of Turkey. These are the areas that has to be really handled very carefully, because eventually it will lead to you to the court phase. And in the court phase, you may not be in a position to expose yourself to certain other legal risks that you have not taken into consideration while you were making the investigation yourself. Fikret, I think this is it for me on the evidence side.
Thank you very much. So we've got 10 minutes to go, Burcu. Therefore, we've got 2 main items, interview and reports. And also you are going to make the closing for the legal consequences. So 10 minutes to go. Okay, let me start with the interview. Interview also, it's another important element of, and also maybe the most sensitive element of the internal investigations, because it comprises of human impact. So the preparation is critical. Characteristics, there are some characteristics of a successful interview and effective interviewer. There's an interview mechanics, question typology, and some legal considerations. So Burcu will talk about a little bit in the details of the interview, and then I'm going to contribute some part. Burcu, is over you.
Thank you. Well, I mean, this slide is more of a, sort of brain running slide, I have to say. So I'm trying to put a lot of questions into it, because it's really important that you ask the right questions at the right time. as long as you ask the right questions at the right time, you should be able to give the right answers depending on your circumstances. I think it's important. There is no right or wrong about how to interview, actually, because it really depends on what is the purpose of the interview, what is the topic that you're interviewing, who are you interviewing. There are a lot of different things that comes into play here. But it's important to give a few important aspects in my view. Who are we interviewing? Like whistleblower, is the whistleblower from or outside of the organization? Does the whistleblower has any duty of care against the employer so that the whistleblower would be required to be present in an interview or not? I mean, for the case of interviewing employees, this is not a major issue because the employees will be having the duty of care against their employers, so that you would be having them in the interview scene, and you would be able to, without offending their rights, you would be able to interview them in a proper environment. But when we're talking about people outside the organization, then this is mostly on a voluntary basis, and you have to be very careful about how you prepare those interviews and what sort of consent you're receiving from the interviewee before even starting your interview. Who's the interviewer? It also depends. I see a lot of questions about should the lawyer lead the process, the investigator. It all depends, really. Again, here it also depends, but definitely people of expertise on the topic should be involved. And it's highly recommendable in cases of criminal liability issues, lawyers are involved. And it's also a question that you have to ask for yourself, whether you want to have company representatives to be included into interview or not. Because in certain cases, you may definitely need them, but in cases, this could be against the advantage of the company to have somebody present from the company. So it's important to make sure that you have more than one interviewer, just to make sure that you're able to have witnesses to what's going on in the interview scene. And also, obviously, it's important to make sure that you're documenting your interview properly. And documenting properly really depends on the type of interview and the purposes that you're willing to achieve from that interview. Sometimes you may need to have minutes of the interview that has to be signed by the interviewee, but sometimes that's not the case, actually. You may just need to report it to the investigation team or the company management, depending on how you run the investigation. Do you need a power of attorney? Do you need a letter of authorization? That could really depend, but just bear in mind that if you're making an interview only by external consultants, including lawyers, your employee may come up and say that I'm not going to give you any information because it's confidential to the company and I'm not allowed to share this with you. So you have to be really well prepared about what can come up, and you have to prepare upfront about what levels of authorization you are allowed to present to your interviewee. It's also critical to assess what level of information, not only authorization, but what level of information will be, exposed to the interviewee. Are you going to show documents? Are you going to show evidence? Or are you going to tell stories? Or are you going to inform about any aspects of the incident or not? These are really all important while preparing for the interview. I have to say, the style of interview is quite critical. You should be really very careful about the rights of the interviewee, regardless of who your interviewee is. It's really important that the company is not exposed to other risks while trying to conduct this interview properly or investigation properly. I think it's important to also assess the timing of the interview. This also should be considered, like, is it a holiday time in any different country? Is it a sick leave that the employee is taken? So it has to be, you have to be very careful about those areas. Remote interviewing is an aspect that came into our lives after COVID. I've seen a question around that, what has been impacted during COVID time. This is actually one of the new figures that came to our lives. There, it's really, I mean, if there's any possibility to lead to any contentious issues, any conflicting issues, I highly recommend that the interview is conducted face-to-face. Only in cases of informative interviewing or more friendly interviewing, remote interviewing styles are working, because you may never know who is behind the camera. I mean, you may not be in a position to know who is, you know, behind the angle of the camera that you have, and whether the interview has been illegally recorded or not. So I think these are the important aspects that I can come up in our limited time.
Thank you, Burcu. Burcu didn't say, but, yeah, thank you. Burcu didn't say, but she meant that interview actually is a kind of art. Therefore, it's quite difficult, and there is no black and white sometimes. But still, there is a question typology you can use in interview. So there are 5 categories for your information. I'm not going to get into detail, but first 3-1, these are the routine interview situations. You are trying to gather information, but these questions must be non-confrontational, non-threatening, and should encourage the subject to engage in the communication. And the last 2 are quite sensitive. If you think that the if you think that you have some reasonable cause to believe the respondent is not being truthful, then you start assessment questions. And the last one, admission seeking questions. This is the most sensitive time of the interview. And in my profession, I'm always saying that the success, the measurement of my success in any fraud investigation is to make the subject, the respondent, to admit his or her crime. So that's extremely important admission process. And the last point is report writing. So you spend too much time in the internal investigation, you are collecting evidence, you interview many people, and you are just building evidence. And to show the quality of your work is the report that you are going to write. That's extremely important. If you, I mean, regardless of the quality of the work you've done today, to date, if your report is not good enough, then unfortunately, all the work it's going to be meaningless. So it's quite that's the reason why it's quite important. There are some characteristics of a good report: accuracy, clarity, impartiality, and relevance, and the timeliness. So if you can stick to these 4 characteristics, most probably you are going to have a good report. And I want to draw your attention to one important things in the report writing: conclusions and opinion, because that most of the time it's coming to us as a big issue in many investigations. Whether we should include a conclusion or we should state our opinion. So when I say the conclusions and opinions, you can see that it is similar, but there are some differences. Conclusions are based on observations of the evidence. However, opinions calls for an interpretation of the facts. And I mean, as a fraud investigator, we don't want to write conclusion at the end of the report specifically. We are trying to write down all our findings, which will make the reader to come to that conclusion. If they are not able to come to that conclusion, it means that our writing report is not clear enough for the reader to understand, to come to that conclusion himself or herself. That's quite critical. And opinion, it depends on the technical knowledge, then it is possible to provide an opinion in the report. Otherwise, it's quite dangerous. So we just get away from this kind of opinions in the reports.
Yeah,
Before, just a second, Burcu, before closing the reporting side, maybe I can draw attention to one point. Chronological order and the transaction-based order is important. I mean, first, chronologically, it should be ordered in the report, and also based on the fraud scheme or misconduct, you can classify your findings in the report. So it's gonna make the reader to understand the issues much better. I think that's all I want to say about the report writing. That's on you, Burcu.
Thanks. Yeah, before starting with the corrective actions, maybe I can just make a summary of my understanding of report writing as well. On our side, I mean, our experience shows that it's really important to have the management to make an informed decision. And that requires a number of items to be reflected clearly in the report. Whether the allegations are validated, and if they're validated, under which evidence is linked to which allegation, and then obviously the conclusions of the investigator or the lawyer who is writing the report. And recommendations on how to proceed with the investigation. With the report actually written down and submitted to the management or to the ethics committee, whoever would be the responsible party to receive the investigation team's product. We're now coming into the closure of the investigation and then to what happens afterwards. What happens afterwards is actually, it's really important to act upon the findings of the investigation. And if you receive solid recommendations and if you receive validation of allegations and solid recommendations on what to do from your different external counsels or investigators, auditors, you should be, as the management of the company, acting upon the results. One aspect could be corrective actions that are imposed to the employees. This could be already subject of a compliance policy or disciplinary procedure that has been adopted by the company. So you have to make sure that whatever action is taken, this is compatible with the internal company rules and policy. And while taking those corrective actions, it will be obvious that there will be other people included into the process. So your HR will be joining in, if not already. Your, if that's relevant to a specific employee, then the reporting of that, the supervisor of that employee will be most probably informed of the actions that are to be taken. And potentially these would be also discussed by those number of different peoples. So it's important to give time to those discussions and action items and take the right discussion for take the right decision and action for the company. Employment law procedures and rules has to be followed during that process. I don't think we have sufficient time to get into details of those, so I will just skip that. But I think it's important to understand what protections are available under employment law for the employee, what protections are available if you're talking about legal remedies and third parties, what protections are available under different laws for the suppliers or for customers or for the third parties who are going to be curing or remediating the company in respect of any potential harm that could be caused by the incident happened. And again, I'm turning back to, if there are any legal reporting requirements, that has to be properly placed by the relevant authorities as one of the outcomes of the investigation. So, I mean, there are lots to say around that, but I think we have no time already. So I'm just stopping here.
Yeah, Burcu, before closing, especially I want to thank to Levent Çağlayan, he asked many questions. So the one question, maybe we should touch upon that. What are the best exercises for facilitating whistleblowing and encourage people to give tips? I think this is the most critical ethics and compliance issue all over the world, not only in Turkey. I want to give a couple of tips to Levent Bey. The speak up culture, in order to foster and nurture management's commitment to ethical values, is important. As I said, lead by example is extremely important in my opinion. And also encourage people to speak up, and you should use the channels, and it's related to tone from the top to across the company to encourage people. And this lead by example should be done by showing the statements, behavior, actions. Especially management, board of directors should behave when they need to take hard decisions, especially related to the internal investigations. At the end of the internal investigations, if we've got evidence related to an employee, and if we should take an action for that employee, this action should be taken. If not, then there is a big problem. So in such an environment, the employees will be able to speak up. Otherwise, they don't want to speak up because they might fear for the retaliation, or they may think that nothing will happen as a result of this reporting. Mm-hmm. So, Burcu, you want to say anything about this?
Maybe just add a few items. You know, reporting channel is quite important. Who is the whistleblower expected to report? That's very critical. What is the environment and mechanism that is made available to the employee? This is also critical. I mean, I have seen a lot of cases where the company is in the position to make sure that the number of fake or unnecessary whistleblowers or tips are less than the solid ones, so that they would give the time and effort, sufficient time and effort to rather tracing the right tips. But in certain cases, if the balance is wrongly established, then the whistleblower is sort of expected to make its own internal investigation before making the tip to the company. I think that's a very critical balance. The companies has to make sure that in their compliance programs or in their whistleblower policies, sufficient framework is given for them to be able to freely tell the honest information that they have in respect of the incidents that they learn in the company. I mean, there are many other things, but these are very critical, especially in the circumstance of Turkish companies.
Especially anonymous whistleblowing mechanism should be
yes, that's another thing.
Yeah, in the last couple of years, there are lots of good softwares where where the anonymous platform can be maintained. So I definitely encourage companies to set up anonymous whistleblowing mechanisms. And one question, if I don't know if you have seen, Burcu, can a lawyer be a witness in court? Yeah,
the answer is yes, I have to say, but that really depends on which court, about what context. It's really, I mean, there are a lot of things that has to be discussed around that question. A simple answer could be, there is no impediment for a lawyer to be asked to be a witness, but the question is, what is the context and what information can be provided by the lawyer, and what is the role of the lawyer in its involvement in the situation? So I think these are more important, because in any case we also still have the attorney-client privilege. Like, for instance, if you're in a defense position, I mean, that's something else. We are not talking about being a witness in case of a defense attorney position, but that really depends on the circumstance. There could be cases where the lawyers could become witnesses.
Yeah. One more question: what is the most effective and efficient way, especially for a finance company, employing forensic investigators or receiving consultancy when necessary? I mean, especially finance companies, as far as I know, they may maintain forensic investigators or internal auditors in-house, but I can see some tendency that some companies are some companies engage some external parties, not for a specific fraud investigations, but for a general consulting services. So whenever they encounter any fraud issues, they just call and they want these service providers to start the investigation. So you can use the external sources definitely. Burcu, you want to say anything on this?
Not really. I think you covered it up.
Yeah.
Thank you.
Okay, I think we touched upon all the questions, and so it's time to finish, Burcu. And thank you very much for the audience for listening us. And I hope the information we provided will be helpful to you and for your organizations. And thank you to BCCT to create such an environment, such a platform for us to connect with you. Burcu, you want to say?
Yes, there's just a recent comment on the attorney-client privilege issue. Okay. I just want to make one comment on that because I think that's critical. In-house counsels not being able to benefit from attorney-client privilege is a practice that is developed in our country by the competition authority. So, I mean, I also have to say that I also have this understanding, but still, I mean, our laws are not explicit and clear enough to make such a clear judgment for any type of case that we're talking about attorney-client privilege. For competition investigations, definitely they're out. So you have to have external counsel to benefit from that shield. Yeah, and sorry for that, and thank you for listening us. It was really pretty nice for me to be presenting today together with Fikret in the hosting of British Chamber of Commerce Turkey. And if you have any questions, we'll be happy to answer. I think Dilruba Hanım just dropped our communication details in the chat box. And hope to see you soon all.
Yeah, thank you very much again.
Thank you very much.
Thank you. Bye.